decided in 1984 by a bare quorum of 6 justices.
Is this the fascist goal to clog up the system? Yes. The Chevron deference was originally celebrated by conservatives because it was ruled in a manner favorable to the Reagan administration. But in the recent decades, it's become a target for the far right because they see it as instrumental in the administrative state, which is something that they want to deconstruct entirely. I mean, you can read the Wikipedia page, man. This is huge. It's probably bigger than Roe v. Wade. Chevron is probably the most frequently cited case in American administrative law, but some scholars suggest the decision had little impact on the Supreme Court jurisprudence and merely clarified the court's existing approach. Not anymore. It's not the existing approach anymore.
Justices triggered a marked departure from the traditional judicial approach of independently examining each statute to determine its meaning. So some skepticism here of whether that case was originally decided correctly. The Supreme Court now saying it was not. Chevron is overturned, and there's going to be enormous questions now, Carl, for administrative agencies across the federal government as to how they move forward with interpreting rules when there is a gray area in the law. A lot of uncertainty now.
This basically like breaks the system. There's literally like this is like a bedrock of the way the government functions now. This is not how it works anymore. You know, like there's no way around it.
For federal agencies, Carl, back over to you.
And Eamon, is the idea that they would have to continually check back with Congress, or is it just up to Congress to kind of micro-legislate all of these elements?
Yeah, look, I mean, we're going through this this decision here this morning. And
yeah, the Supreme Court just ruled that it's essentially legal to bribe state officials, or at least in some specific circumstances. I think they also ruled today that it is lawful to punish homeless people for being out on the streets, even when there was no adequate housing for them to stay at otherwise.
See if the Supreme Court is giving any guidance here, but I mean, one option would be that the Congress has to go in a detailed way. And
they also ruled on this. Oh yeah, also today they ruled that we were too mean to the January 6th insurrectionists. That's right, the Supreme Court unironically is like, yeah, the beer hall putsch guys were overcharged. The Supreme Court ruled the Justice Department overstepped by bringing obstruction charges against hundreds of people who rioted at the U.S. Capitol on January 6, prompting at least some of these cases to be reopened. Wow, a 6-3 majority. That's crazy. Wow.
And detail all the stuff that regulatory agencies have been doing between 1984 and until today. Another option would be that, the federal agencies would get some deference unless there was a lawsuit challenging that. We'll have to see what the Supreme Court said. There's a lot of fallout here still to come, but Chevron...
Oh, yeah, there is. Let's talk about the Jan 6 ruling.
More breaking news, this time about the January 6th rioters. The Supreme Court has just ruled. Let's get to Shannon Bream. What did they say?
So what they have said is that one of the statutes the Justice Department used to charge hundreds of different January 6 defendants is no good. And that includes President Donald Trump, because he has actually had 2 of these counts against him in the Jack Smith D.C. case against him, that federal criminal case that has been on hold here. So what essentially they say is this statute, which was passed in the wake of Enron, they say it doesn't fit here. He says, given that
Kentucky Brown Jackson voted to let the January 6 riots go, ACB dissented with the libs. Interesting. What strange bedfellows we make.
The subsection
Did I say Kentucky? Sorry, I'm tired.
Enacted to address the Enron disaster, not some other far-flung set of dangers like what happened just right over here at the Capitol. It is unlikely that Congress responded with such an unfocused and grossly incommensurate patch in English that essentially means that all of these people who were charged under this particular obstruction statute for January 6th, that is no good. The dissent, this is a very interesting vote.
Kentucky Jackson sounds cool. Kentucky Jackson sounds like something All Might would scream before punching somebody into space. It's a very American name. Kentucky Jackson. That's like Duncan, Idaho shit.
Because the dissent is actually written by Justice Barrett, and she is joined by Justices Sotomayor and Kagan. She says that Congress did intend for this kind of conduct to be brought, particular obstruction charge. She thinks the majority got it wrong. But what it means is a big headache for the DOJ and good news for hundreds of January 6 defendants charged under this statute, again, including President Trump.
It's a big ruling, too.
Yeah.
I mean, these are big cases. Let's bring back Andy McCarthy, Jonathan Turley. Andy, this is, what does it mean? Big picture for these January 6th
and how many people
defendants.
And how many people was this statute? Did it apply to all these cases?
Well,
I want the
applied to
details
all
on
of them,
this.
or many of them, Dana, in the sense that it was charged in them. It doesn't mean that everybody who pled guilty, for example, which happened massively in that connection, doesn't mean that all those people have preserved their right to complain about that on appeal. So how many of them it will actually benefit is questionable. But the importance here is that they have found that this is an evidence impairment statute. So in other words, for this kind of obstruction to apply,
More breaking
you
news
actually
this
have
time.
to corrupt the documentary evidence that's being presented in a proceeding. The way the Justice Department tried to...
I don't think the consequences of this in the immediate sense are going to be that significant, but the fact that they took this case and ruled the way they did is an indication that they're trying to show up support, like this is a partisan decision. The idea here is like, if we indicate that there was legal wrongdoing in the charging of the January 6 rioters, that like furthers the case from the far right that they're like innocent little beans who were overcharged, or who did nothing wrong. Yeah, but clearly KBJ thought there was something valid here and I trust her. Well, you know who I don't trust? Liberals. That's the confidence. Or that's the whole point. It's just meant to like challenge the narrative. What about the homeless encampments?
But we do have a ruling. This one is on homeless encampments. So this is a case, City of Grants Pass, Oregon versus Johnson, and what the justices are considering here, whether the enforcement
Yes, she
of
is.
generally applicable laws regulating camping on public properties constitutes cruel and unusual punishment prohibited by the 8th Amendment. So we're just getting word in. This is the first opinion that has come out today. Tom, what more do we know about the significance of this case, one we've also been covering here for the last few months?
Yeah, this is one of those really interesting cases I found. I found it fascinating. I was actually assigned this story to cover this case during the day of the oral arguments. For our viewers at home, just for some quick background, this all originated out of Grants Pass, Oregon. And, a very big point with this story, above all else, homelessness is a very serious concern for some parts, for some Americans across the country.
All right, you're waffling, man. I gave you a chance, News Nation, and you're f***ing it up.
That's right, Christine. So if upheld, things will essentially stay the same. But if overturned, cities could punish people for sleeping outside in public, even when there are no shelter options.
This is the most consequential decision relating to homelessness in my lifetime.
The small city of Grants Pass, Oregon, could shape the way cities in Washington and around the country handle homelessness.
This video is from before the ruling was announced, so they're going to talk about what might happen if they rule against, which they did.
The Supreme Court, siding with Grants Pass, would allow cities to ban camping and fine and jail homeless without providing a shelter space.
Those cities who take that approach, it could result in a mass migration of unhoused people from locations where their existence is prohibited to other locations across the Ninth Circuit where it's not.
Seattle University law professor Sarah Rankin says it could mean more policing approaches and reduce investments in homeless services.
It'll make people less likely to emerge from homelessness.
But some government leaders, like Seattle City Attorney Ann Davison, supported the Supreme Court hearing the case, arguing court decisions have paralyzed communities' ability to address homelessness. Mayor Bruce Harrell's office told us the court's decision doesn't change the city's approach, which leads with offering shelter and services, ensuring people come indoors at the same time as we keep spaces clean and accessible for everyone.
I'm Mayor Kevin Schillingham calling the regular meeting of the Burien City Council.
Meanwhile, this year, the city of Burien has tightened its camping ordinance, adding buffer zones to stop people from sleeping within 500 feet of schools, libraries, and child care centers. These restrictions are not being enforced because the King County Sheriff's Office is waiting for a federal judge to decide its legality.
Cities will be emboldened to do those things, but they will be met with the sort of arrows that lawyers still have in their quiver.
And Rankin says that is because
super cool. Insurrection, legal. Homelessness, illegal. Regulations, illegal. We got it, boys. The future is now.
All right, let's get to Ron now. Hey, Ron.
Well, another busy day for the U.S. Supreme Court. One of the opinions they just released focused on what has been a huge issue here in the Metro Phoenix area, homelessness. In a 6-3 ruling, the court decides that cities can, in fact, enforce bans on homeless people sleeping outdoors, on sidewalks, in a place like The Zone, even if there aren't an exact number of beds available.